Good afternoon, everybody. It is now 12 o'clock here on the East Coast of the United States. And that means it's time for Garden State CLE Zoom at noon. Really important one today. It is the DWI Trial Notebook, which we're going to go through. Everyone should have received this in his materials. Try to follow along in your lesson plan as we go forward. With me today is DWI expert and trial attorney extraordinaire, John Menzel, aka
Oh, that's me?
Johnny Badlaw. That's
Okay,
you.
okay.
All right, Johnny, listen, when you and I designed this thing, the whole idea is it for professionals, prosecutors, judges, and attorneys who are in the middle of a DWI trial to be able to track what's going on in real time and be able to make sure they've done everything they're supposed to do or not do. And alternatively, if a legal issue comes up during the course of the trial, you'll be able to very quickly find it in here and then advocate whatever position you're going to take. Okay. So having said that, let's go to the beginning. Part one, proof of facts. Now, there are multiple burdens of proof that you utilize in the course of a DWI trial, and some of the associated motions that go on before or sometimes even after the case is heard. So I want to kind of go through them with you. The definition of the burdens of proof are set forth in NJR, New Jersey Rules of Evidence 101B. Burden of persuasion means the obligation of a party to meet the requirements of the rule of law, and the fact has to be proved by preponderance of the evidence, clear and convincing evidence, beyond a reasonable doubt, or other such standard of law. And we'll have a few more. We'll be talking about probable cause. We'll also be talking about reasonable articulable suspicion. These are all in play in a DWI case. Burden of producing evidence means the obligation of a party to introduce evidence when necessary to avoid the risk of a judgment or preemptory finding against that party. Johnny, I was thinking about this in the context of your favorite case, State versus Romano. The drunk driving case where they raised the issue of necessity as a defense, which was permitted under New Jersey common law. But the burden of producing evidence is very clearly it's in play for prosecutors, because after the defendant introduces some evidence of the necessity, then it becomes incumbent upon the prosecutor to go forward and put in evidence to prove beyond a reasonable doubt that the necessity defense doesn't work, right?
So yeah, and it's interesting because that's the actual term they use in Romano, some evidence. I don't know if that means preponderance or what, but I guess it means enough. Something, it's got to be less than even a preponderance. It's like the converse of proof beyond reasonable doubt, wouldn't you say?
Well, you know what? A lot of the statutes put a burden on the defendant to introduce evidence, and often it's just preponderance of the evidence standard. I'm not so sure that that's constitutionally permissible to put any burden of proof on the defendant. But by the same token, these are affirmative defenses, and so the burden of going forward with the evidence is on the defendant to produce some level of evidence, and then the state has
Some
to go back
evidence,
and
whatever that means, whatever that means.
yeah, I mean, and it's no different in the DPs and petty DPs. If you're going to use, like, say, self-defense,
Self-defense.
that comes from right off the top of my head. But in the DWI context, as we're discussing, State versus Romano would be the issue there. When you're a judge or defense attorney or a prosecutor, and you're going to be arguing at the end of the case that the state has to prove each element beyond a reasonable doubt, you're going to go through those elements and argue which ones have been or have not been proved beyond a reasonable doubt. The definition has been set forth by the New Jersey Supreme Court relatively recently, back in 1996. When I say recently, over the 70-some year history of the court. State versus Medina is the case, the definition here, and it's been adopted into the New Jersey jury charge. You guys can just read it over. The honest and reasonable uncertainty in your mind about the guilt of the defendant after you've given full and impartial consideration to the evidence. And you may just actually want to read a little bit of this into the record when you do your closing statement if you're a defense attorney and there's something that's in question. So you really get the judge to start thinking about whether or not he or she is satisfied that the evidence reaches that standard and that person is so convinced, so to speak.
It's funny when you put that in there, Bob, that right out of the jury charge. When I do trial de novo, when I do my brief, there's a standard of review section I put in. And basically it's lifting that charge up and putting it in there to remind not so much the law division judge, but probably his clerk, what the standard is.
Sure.
And I guess the law division judge can gloss over it. He thinks he knows it, but I really write that for the clerk and put that jury charge in there. And then when we get to what? Clear and convincing evidence? We
Yeah,
put that in there if it's appropriate. What is that, Bob? Evidence so
oh,
clear, direct, and weighty as the
and
cause to find.
convincing, weighty
Yeah,
and convincing,
and
as to enable the
convincing
fact finder to come to a clear conviction without hesitancy as to the
without hesitation.
position.
That's right. That's
Um,
right. And Ray Seaman,
that's
one
right.
of
All
my
right.
favorite
So
cases.
it ought to be. It's got all kinds of bad stuff going on in that case. Let's talk about these actual burdens. We mentioned a moment ago with the definition based on State versus Medina of proof beyond a reasonable doubt. The Title 39 is really kind of interesting because a lot of it goes back to 1925, and the legislature really kind of kept things real simple. And to this day, it's real simple. Interestingly, the definition of driving under the influence of alcohol is not in the statute. Okay, driving under the definition of driving under the influence of drugs, it's not in the statute. All this stuff comes through the case law, and the burdens of proof in a drunk driving case, again, there's nothing in Title 39 that talks about that. It's 100% coming through the case law, either in the appellate division or the Supreme Court.
And
So
it starts as early as 1917 with State versus Rogers. Remember
that's
that
right.
case?
A
I
very,
mean,
very
you were just out of law school then, right, Bob?
I was in my second year. Yeah, Rogers is actually cited all the time, and it's a really good definition of being under the influence of alcohol. So here's the burdens in a DWI case. And again, if you get into a fight, you can put this in your oral argument in your brief. So where does it say that the burden of proof in a DWI case is beyond a reasonable doubt? It's in the following cases: State versus Grant, old appellate division case from '84. A much older case, State versus Glynn, 20 New Jersey Super 20, which is the only case of citation I can remember because it's 2020, number one. And number two, this is the case that deals with the synergistic effects of alcohol and drugs. All right. Um, Olenowski most recently picked up on this. This is the Olenowski 2 case. To establish guilt on 39-450, the state must prove beyond a reasonable doubt that the defendant was driving while under the influence of at least one of the specified types of substances. In particular, the state must prove both the facts of intoxication and the cause of intoxication. All right. Under the influence of drugs cases, the prosecutor must prove one, the defendant was intoxicated, and two, the cause of intoxication was narcotics, hallucinogens, or habit-producing drugs. Notice two things here, Johnny. The Supreme Court left out chemical inhalants, which is a very big part of Title 39, and they also didn't put in the element, got to show the guy was driving a motor vehicle, all right? Excuse me,
Well,
operating.
you know what, Bob? You might even say it applies to whether it's alcohol or not. Now, generally, that's not a problem in cases, but every now and then you get a wacky defendant. I'm sorry, can we say that now?
No,
Who's acting in a very irrational manner, but there's not even proof of alcohol, no odor on the breath or anything. What do you do with that? I guess Olenowski says maybe you got a winner there.
maybe you do. Or you have somebody who's just crazy. You got a lot of people like that. Now, the proof beyond a reasonable doubt comes up in at least two other contexts in a drunk driving case. And I want to make sure everybody knows this. So when you're in court and you're on your feet and you're reminding the judge what the standard of proof is, you're going to be on solid ground. Miranda hearings, okay? If you're trying to suppress a admission or a confession by your client on a pretrial hearing, it's Rule 104C is the rule that controls that. And the burden of proof is beyond a reasonable doubt. And by the way, just to, a lot of attorneys, especially the younger ones, they're afraid to have their clients testify during the Miranda hearings. In fact, during any type of a motion to suppress, and there's really no downside to it. You can have your client testify. The things that he says in the hearing cannot be used against him substantively ever in the trial of the main case. And the only time it would ever come up during the trial is if the defendant says something that's at odds with something that he said during, if he testifies during the trial and says something different.
There's one other point to be made here, Bob, and that comes down to knowing your judge.
Mm-hmm.
There are some judges who are disciplined enough to separate what they hear from a pretrial hearing versus what they hear at trial. And then there are judges who are not. I think there's a nasty rumor out there that judges are human beings.
Mm-hmm.
And, it's like the old toothpaste out of the tube. Sometimes a judge will hear something and it will have a direct impact. I remember when I argued State versus Korobchak in the Supreme Court, Justice Albin actually suggested that. And something uncharacteristic happened in Korobchak compared to, say, Romano versus Kimmelman, where instead of simply affirming the conviction based on the observational evidence, because that's what the original conviction was based on, they actually vacated the conviction and remanded it. And part of the theory, although not expressed in the opinion, I think had to do with the fact that maybe the admission of that breath test result tainted the fact finder somehow.
Johnny, take a second if you can and see if you can find a copy of the State versus Medina from 2002 in the appellate division, because there's language in there that really answers this question. And at minimum, I want to give everybody the citation on that case. Yeah, this is a different Medina than the one that defines the proof beyond a reasonable doubt. The Medina I'm referring to is a different Medina. It's an appellate division case, but it's right on point with the topic that John just brought up. And the appellate division says we expect trained judges to be able to compartmentalize what they've heard in pretrial hearings that are not part of the evidence in the main trial and segregate it and not let it play any part in the decision they make based upon their consideration of the relevant facts that were admitted into evidence and the law that's applicable to that. I want everybody just to look toward the bottom of the decision. I wouldn't call it dicta, but it's part of the case, where the appellate division says what they expect of trained judges when they hear all kinds of evidence outside the main trial in, motions in limine, pretrial hearings, motions to suppress, bail hearings, whatever it may be, domestic violence.
Well, here's what it says. Trained judges have the ability to exclude from their consideration irrelevant or improper evidence and materials which have come to their attention. And that's quoting a Supreme Court case, State versus Kunz, Kunz, 55 NJ 128.
That's an old murder case.
9 case.
Yep. I think that might have been from Mercer County, actually. Let's talk about something that's really important and new law as far as I'm concerned. And that's another time when proof beyond a reasonable doubt will come up in the context of a drunk driving case, beyond Miranda hearings, beyond the substantive guilt of the defendants, and that deals with sentencing. Okay. All right, Johnny, listen, I want you to comment on this because I know you're kind of really on the cutting edge of this. We're talking about the burden of proof at sentencing in a drunk driving case. Okay. It is beyond a reasonable doubt. This came up in the appellate division decision of State versus Zingis, and this just to tell a quick war story. I was reading over the appellate division case, and they came out and they just say the burden of proof in sentencing is beyond a reasonable doubt. And I'm saying, oh, that's interesting. I never knew any of the rules of evidence applied in the sentencing except for that the evidence be, trustworthy, reliable, and in the interest of justice. And they didn't cite any law to that at all. They just said it.
So there is law to support that, Bob.
There is now, but when the appellate division said it, there wasn't. Then the Supreme Court comes out in Zingis. They say the same thing, but the Supreme Court has the advantage of having the decision from that same term from the United States Supreme Court. Can you talk about that, the Erlinger decision?
Sure, yeah. First of all, you can't conflate the burden of proof, the method of proof, with the standard of proof that's got to be applied. Obviously, the rules of evidence don't apply, but still the burden of proof is, generally speaking, beyond a reasonable doubt, with one notable exception. And that's with regard to the existence of a prior conviction. And that's, what was it, New Jersey versus Apprendi?
And
Apprendi
versus New Jersey.
Apprendi versus New, thank you, Bob. I'm a little backwards, what can I tell you?
Everybody.
And then there's United States versus Elaine, but then Erlinger versus United States came out. And that's a really interesting read. A lot of dicta from Justice Gorsuch, but he's even suggesting that the exception carved out by Apprendi and Elaine maybe doesn't apply. Now, granted, in Erlinger, the issue was whether a jury should find that the person was a career criminal for sentence enhancement purposes. But boy, Justice Gorsuch spent a lot of time talking about proving the existence of a prior. And I can tell you, I have done research on cases from time to time and actually generated enough absence of records to get a judge to question the use of a prior for enhancement successfully. And It's something I think, you get a person who's got priors, you got to do the research. You got to write to the prior courts. You got to write to the prior police departments. You got to talk to your client and see what exists out there.
Well, Johnny, I want to give everybody some legal advice about handling sentencing issues, not only in DWI, but also in other things where there be an enhancement that's mandatory: driving on the revoke list, driving without liability insurance, shoplifting, I don't know, cell phones, maybe. I don't know what these are off my head, but let's just focus for a second on DWI. All right. If your client has prior offenses, it seems to me there's two methods that the state has to utilize to prove it beyond a reasonable doubt. If it is a so-called, air quote, Zingis case, meaning that it occurred between 2008 and 2016, typically in one of the designated counties where Trooper Dennis was active, then the state will have to prove that that conviction exists following the procedures that were set forth by the New Jersey Supreme Court in Zingis. That's how the state proves it beyond a reasonable doubt. But for everything else, something that's outside the Zingis window, something that's before 2008 or something that's after 2016, I think that the state just needs to present a certified abstract to the Motor Vehicle Commission, and the court finds that to be in the interest of justice and otherwise reliable and trustworthy. Uh, the judge could be persuaded beyond a reasonable doubt on the basis of that evidence. And do you agree with this, or do you think there's
Yeah,
something?
I don't disagree with you about that. Let's put it this way. It's kind of like a prima facie case at sentencing. You present the abstract.
Right,
That's what then shifts the burden to the defendant to come forward affirmatively with maybe some evidence to undermine that presumption, or I
right.
should say, permissive inference.
Permissive interest. But the point I'm trying to make for everybody is please be aware that these are three situations in the drunk driving case where the burden of proof beyond the reasonable doubt is going to come up. Okay. On the substantive offense, proving each element of drunk driving beyond a reasonable doubt. During a Miranda hearing, it's as to the voluntariness of the statement by the defendant, and in a sentencing. All right, the judge has to be satisfied that the prior convictions exist beyond a reasonable doubt. And if there's some question about it, you got to stand up and argue that one way or the other if you're a prosecutor.
And keep in mind what the question was in Zingis and Cassidy. It was about the validity of a breath test supporting the conviction. So it was
Mhm.
a non-existence kind of a situation that gave rise to that burden of proof. So I don't think the appellate division or the Supreme Court were really extending themselves by saying it's proof beyond a reasonable doubt.
Well, at least they had the Erlinger decision to kind of hook on to.